Hi, hello and welcome to our LinkedIn live broadcast coming to you live from Washington, D.C. We are not in a prison cell. We're at the Russell Senate office building with a couple of esteemed guests here. And the purpose of this conversation is to provide some thoughts and observations and ideas based on what is happening in Congress relative to crypto legislation. And while we don't have all the answers, I don't think anyone does in terms of what's going to happen next. We are here in Washington having a lot of really productive meetings, and we've got certainly some insights to share. And we're very fortunate to have a couple of guests here, and I will ask them to introduce themselves. Rika.
Thank you, Bobby. I'm Rika Khurdayan. I'm U.S. Chief Legal Officer for Bitstamp, heading Bitstamp's regulatory and legal affairs in the U.S. I have been with the company for about 18 months. Prior to joining Bitstamp, I ran a law practice in New York since about 2017, focusing almost exclusively on blockchain and crypto-related matters.
Cool.
Thank you.
Yeah, Chris Land, General Counsel of Senator Lummis in the U.S. Senate.
And as I mentioned, I'm Bobby Zagotta. I'm the CEO for Bitstamp USA and the Global Chief Commercial Officer. Obviously for Rika and I, we are very, very interested parties in what is happening in Washington and why, both in terms of the content of some of these bills and the process, frankly, and the possibilities as to when or how or to what extent a code of law might come into being. For those of you who might not know much about Bitstamp, Bitstamp is the longest running cryptocurrency exchange, founded in 2011 in Europe. And Bitstamp, I think more so than others, has really centered its existence on regulatory compliance. So we have the most extensive regulatory licensing footprint, and we're proud to have a BIT license here in the U.S., 42 money transmitter licenses or money services businesses, as well as lots of licenses in Europe and Asia as well. And so that we came to Washington, Rika and I, to learn as much as we can about what is actually happening and what's the perspective and sentiment across the House and the Senate. And we've heard some really encouraging things and also some things that give us pause. But perhaps to start the conversation, I'll ask you, Chris, if it's okay, to just give us a lay of the land from a legislative perspective. There's a few bills out there. What are they, and what are the basic differences between them?
Yeah, thanks, Bobby. Appreciate you having me. I do think there's a wide variety of crypto bills in the marketplace, as it were, in Congress now. I like to say that the puzzle pieces for a solution are all there, and now we just have to figure out how to put all the puzzle pieces together in a way that we can get 60 votes in the Senate and get it to the House and then get it to the president's desk. So all the policy ideas are out there. It's just a matter of seeing how they fit together. One of the policy ideas that I'm most proud of is my boss's bills, the Lummis-Gillibrand Responsible Financial Innovation Act. That bill is the most comprehensive crypto bill in the United States, maybe the world, that deals with every facet of crypto regulation, from tax to anti-money laundering to commodities, securities, banking, stablecoins, consumer protection, and even has some pretty great definitions in there. So that's the kind of the main driver of the crypto conversation in the Senate. In the House, we have Chair McHenry's FIT 21 Act, which is the Marketplace Regulation Act that deals with things like what's a security and what's a commodity. It also deals with crypto exchange registration and how it divides power between the CFTC and the SEC, just like our bill does. Then also over in the House, there is the Clarity for Payment Stablecoins Act, which is a piece of legislation that provides a registration and operating regime for stablecoin issuers in the United States, and tries to give prudential treatment and oversight from the banking regulators to stablecoins. So that's kind of the lay of the land at the moment.
That's great. And previously there was a Stabenow-Boozman bill. What is the status of that?
So the official title of that is the Digital Commodities Consumer Protection Act. that was introduced last year in the Senate Agriculture Committee by Chairwoman Stabenow from Michigan, Ranking Member Bozeman from Arkansas. They jointly negotiated that together, and that just addressed the CFTC side of the crypto equation and not kind of the whole, like, the securities part of the equation and stable coins. It just deals with Bitcoin and Ether essentially, and how that would be regulated by the CFTC at an exchange level.
Got it. And is that something that's still active, or is that kind of?
Every time there's a new Congress, all the bills have to be reintroduced. And that bill was introduced in the 117th Congress and has been reintroduced in the 118th Congress. So could still be reintroduced at some point in the next few months. I will say, though, the Agriculture Committee is very busy with the Farm Bill right now, since that has to go through there, and that only happens like every 4 or 5 years, I think. So they're very concerned that they have to pass the Farm Bill, and they don't necessarily have to do crypto legislation. So I think they're very focused on the Farm Bill right now.
Okay, makes perfect sense for the Ag Committee. Are there any common denominators, Chris, that across these bills, such as security, commodity, jurisdictions, regulatory jurisdictions, et cetera?
Yeah. So some of the themes throughout the bills are, they try to provide regulation of crypto exchanges. What's a security or what's a commodity is another common theme. Trying to ensure that when assets are held under custody by exchanges, that you have a right, they're not on the balance sheet of the exchange, and you have your rights in bankruptcy, unlike FTX, and trying to prevent some of the harms that are happening to consumers after FTX, like having to go to the bankruptcy court to get your assets back. Those are things that shouldn't happen in modern financial services regulation in the US. So just really low-hanging fruit like that, creating disclosures for crypto exchanges to operate and be required to provide certain information is another big piece.
Awesome.
What are some of the biggest obstacles that you faced while putting together this legislation?
Yeah, drafting is quite a laborious process, as you can imagine, but one of the crypto industry is not exactly completely aligned on what policy solutions it's advocating for. So some people want more regulation that's kind of more commensurate with financial services regulation we have today, and like securities and commodities. Some people want a lighter touch regime that's more bespoke to crypto, and then some people are kind of in the middle between the two. So trying to align the crypto industry amongst itself is probably the most challenging part.
Yeah, and maybe I can chime in there from a Bitstamp perspective. As I mentioned, our company made the decision early on, going back to our founders, to embrace regulation and to be licensed. And I think, although I wasn't there at the time, I think the founders' thought process was, they were really obviously big believers in the technology and the importance of it in the world.
Sure.
And they want broad adoption, but they recognize that for many people and many companies to participate with confidence, it's going to have to be a regulated, activity and set of platforms. So that's where we find ourselves. But in the U.S., it's quite challenging today, right? So, Bitstamp, just speaking as one market participant, we just want to do everything right. We just want to follow whatever rules there are. We want to get whatever licenses are required, but it's not clear today exactly what is required or what the rules are, and it really creates a lot of cost and quite a tax on just operating because decision making is so burdened. For every major decision we make, we have to kind of scenario plan what might happen
next.
There's a lot of costs there and a lot of slowness, and for that reason. As many of you, I'm sure, have figured out, some people are just leaving this jurisdiction.
Yep.
Bitstamp is committed to this, to operating in the U.S., and we believe in it. But hopefully, some of these bills can come to fruition, and we can all operate with more certainty.
Yeah, I think we can speak on behalf of many industry players to say that we've really been craving some more, some more clarity in the regulatory space, and Bitstamp is lucky in a sense that we've been in this business for 11 years, and in the crypto world, we're a very mature company, And even we find it difficult and challenging to operate in this space, as Bobby mentioned, because the process is so long and laborious and it's expensive and it takes a long time. But I can only imagine what happens for earlier stage company who are the drivers and the innovators in this space, and for really early emerging companies to be able to deal with this complexity and even the amount of legal spend you're required to undertake in order to navigate this environment. So it's not surprising that a lot of companies are looking at the U.S. jurisdiction as regulatory risk.
Yeah, no, it really is. It's pretty fascinating.
Yeah, and I don't think it bodes well for, kind of our envied spot as at the top of the global financial services marketplace. And I hope lawmakers understand how high the stakes might be here. What is your take? I'm interested in the sentiment of lawmakers, and I'm interested in your impressions as well from today.
Well, Senator Lummis has been very clear from the beginning that, being the world financial services leader makes everything in America cheaper. It makes credit cheaper, it makes goods and services cheaper. But the US wasn't born that way. For a long time, Great Britain was the world financial services leader. Other countries have been, the Netherlands was once upon a time, and that's where the joint stock company came from. So we have to innovate to keep our mantle as the world financial services leader. And everyone agrees that even this technology has a important place in the financial services regime of the future. It's going to happen. It's like the internet from 1998. But, I think we're trying to rest on our laurels a little bit too much. And I do think there are a lot of members here, especially post-financial crisis, post-Dodd-Frank, see the financial services industry as not completely a beneficial part of the U.S. economy, or it's not the most productive part of the U.S. economy, or it's, somehow pungent, somehow behaving inappropriately in the economy.
Yeah, Rika, what are your impressions from our conversations thus far? Is there more optimism, would you say, or pessimism about the ability to get something done legislatively?
So it's interesting because we've encountered both sides of the spectrum. Some people are rather pessimistic about our ability to put any kind of proposed legislation into law in the coming few years, maybe even. What we've heard as well is interesting, specifically about the RFIA bill, is that the way it's constructed and how it's a comprehensive bill that touches upon different, parts of this industry, that some people are optimistic about the fact that maybe parts of the bill could be implemented into law much quicker and rather quickly, rather than the full bill at once.
No, that definitely makes sense. It's hard to move a 274-page piece of legislation.
Yeah, particularly in today's environment, I would think one of the compliments that you and Senator Lummis received in some of our conversations today regarding the RFIA bill is that it's modular. That there's ways to think about it in terms of so quite elegant the way it's constructed, I think. And the other thing I was going to ask along these lines is what level of knowledge about the topic, about blockchain technology, cryptocurrency, do you think lawmakers have a level of knowledge that's necessary here to really understand the nuances and make judgments based on laws and bills, or is that still developing?
Yeah, no, I think generally that, and I don't know, probably the committee chairman and the leadership, I think there's a great deal of knowledge, a good knowledge base there. I think members who are on the relevant committees probably have a little bit less knowledge. And then, I think the average member is probably aware that cryptos exist and what the basic problems are, but there's no need for them to completely, have the same depth of knowledge as some of the committee leadership. I will say though, that when Senator Lummis took office in 2020, there was basically no knowledge in either the House or the Senate about what crypto was. It was mainly in the banking regulators, CFTC, and the SEC. You know, and so I feel like we've come a long way in 3 years. Hard to believe it's 3 years, to be honest, but we've come a long way in 3 years. And in 3 more years, I hope we'll be across the finish line.
Yeah, great.
I thought from our conversations and meetings today that there is a very deep understanding and knowledge of the different nuances in this space, and really the interaction between the different aspects of this technology, and the ways in which, you know, on one hand, security regulations might apply, but not necessarily in all the instances, and how it interacts with, you know, CFTC regulations potentially, what can be done with the asset, how it can be used in many different ways. We had a very nuanced and in-depth discussion, so it was very encouraging, yes.
Well, I'm glad to hear someone was encouraged.
Yeah.
You know, a lot of these meetings, a lot of meetings I have are, you know, we always have bad news because, you know, it's a big bill and, you know, it takes a long time to move. So I'm very pleased to hear you all have good conversations.
Sorry.
Go ahead.
Let me ask this question. You know, there's so much discussed about commodity versus security, and obviously different regulators seem to have a different perspective on it. You know, how do you treat that topic in your bill? And I know Rika also has, you know, an excellent perspective on it, but we'd love to hear it.
So my boss's perspective is that ab initio from the beginning, a digital asset that doesn't confer like a debt that isn't debt or equity or conveys some kind of financial interest in a business entity is always a commodity. And from that perspective, we recognize that there are certain security-like aspects of digital assets that aren't Bitcoin and Ether. Like, you know, you're raising capital to a certain extent, and there are information asymmetries that need to be resolved between whatever issuer-like entity is releasing the digital assets and the end purchaser. So it looks kind of like a security, but it's not really a security, is kind of my boss's view. You know, we've looked at every case that's ever been interpreted under the Howey test from 46 on. There's about 250 cases. There's a long review article that I recommend you read. It's from Rose Cohen. It's called The Inelocutable Modality of Securities Law. It goes through every Howey case and has a giant table. And
that sounds like great fun.
Yeah, it is. You know, it's
about this thing.
Yeah, it's the best one. But it also makes a pretty compelling case that like the SEC's interpretation of the Howey test today is not what the Supreme Court and the federal courts have said Howey actually is. So the SEC is trying to stretch the boundaries of its own authority, if that makes sense. But so that's my boss's view. We have this regime called ancillary assets, which recognizes that and basically says it's not a security. It's like if you're not providing a debt or equity instrument or a financial interest in a business entity, but in exchange for that presumption, you have to comply with certain disclosure requirements.
So I actually thought that it was a very thoughtful and also elegant way to address the main issue that we've been really kind of spinning our wheels in this industry trying to resolve. And the question is always, or like often posed as, is an asset security or a commodity?
Yeah.
And I always say this is not the right question. The question is the transaction with this asset trigger security regulations or not? And it was very interesting and encouraging to me to see how you actually really very elegantly embrace the concept that the asset itself is not a security, but the way this asset is utilized, and if it's wrapped in a part of an investment scheme, and that's where your ancillary assets come in, then of course, absolutely, the Securities and Exchange Commission should have jurisdiction over these types of transactions, but it does not make the asset itself a security, and it does not extend the SEC's jurisdiction beyond that particular type of transaction. And this is very consistent with every single precedent on the topic, starting from Howey and ending really with Ripple and the Terraform decisions. So it's you know, it's one of my favorite personal parts of the proposed bill.
That's I think that's one of Senator Lummis's favorites too. I will say that Yeah, I think like we can all agree that if it's wrapped in an investment contract, but the problematic piece in this whole discussion with the SEC's doctrine at least is the SEC wants to adopt this approach to crypto that allows crypto to morph into and out of being a security. And it's very hard to follow. And it also doesn't give investors the certainty they need about whether they're holding a security or not.
But it's also a moving target, right? Because the industry has progressed really significantly, even in the past 5 or 6 years. The technology changed significantly. The market changed, how we utilize the technology, all of these assets. So in my perspective, when I think about it, when we try to define the asset and the concept of morphing in and out, it's always a moving target. It doesn't give enough clarity or confidence for people to understand how to actually deal with the asset.
Sure. Yeah, no, that's absolutely right. And securities law violations are usually strict liability.
Yes,
like you have to comply, and if you don't comply, there are consequences. So like when you have an embodiment theory and you're trying to morph into and out of, like you can very easily violate the law and not intend to.
That's right.
And it makes it also very difficult for, because when I think of it, any kind of framework will address the issuers of these instruments, but also the intermediaries and third parties interacting with it.
Sure.
So on one hand, the primary issuance, is a little bit more straightforward, but when you're dealing with the instrument morphing back and forth, that makes the life of the intermediaries or anyone else besides the issuer interacting with these assets really hard and unworkable.
Let me ask one more question along these lines. So the way the SEC is going about addressing the issue, is challenging and viewed as challenging by many market participants, right? So it seems to be, using enforcement actions primarily to set precedent and to drive clarity. And enforcement actions, are typically not complete. They're specific to a case or a situation.
But they are viewed as setting policy to a certain extent, right? Because people don't want to get enforced on the same basis.
Exactly. It does drive clarity around a situation, or at least it attempts to, I think. But my question is, are lawmakers comfortable with that approach? Is that approach typical, or are lawmakers feeling like market participants are, which is there any way we can just understand the rules up front and then we can all, adhere to them versus, live under the risk of some kind of enforcement action?
Yeah, so Congress only tends to act when it needs to. When there's a problem that needs to be fixed, and there's a lot of members of Congress that would argue that the SEC has the capabilities and the tools they need to police the crypto markets. Gary Gensler's favorite saying is he's a cop on the beat, at the SEC. So his issue, like a lot of folks would rather just say there is no problem, like the SEC is going to handle it. But as the recent court decisions really evidence, the SEC, like it's a legitimate question whether the SEC has the legal authority they need to take these actions, and I think the courts have reflected that.
Yeah, I'm curious, and I guess the best way for Congress to address that situation is to pass a bill, right?
Yeah,
pass a law that would more clearly define their role and their authority, and the CFTCs
and that's actually Congress's job if you think about it. Like when you have an interagency issue about who has the authority, that's not like only Congress can fix that kind of problem.
Yeah,
that's not a especially two independent agencies that the president theoretically doesn't have any authority or not much authority over, right? So
is there any consensus across these bills regarding the role of the CFTC versus the SEC as primary or secondary?
Yeah. So generally speaking, all the bills that have been proposed have given the CFTC an equally prominent role, if not more so than the SEC in the crypto space. That was one of the arguments Senator Lummis made in her Coinbase amicus filing, and the enforcement action the SEC brought was that in none of the legislation introduced in either house has the SEC been given primary authority over crypto. So why should the SEC be able to argue that in court?
Yeah, no, that's a great point. And those agencies seem to have such different kind of modus operandi and style, both of regulation and enforcement, but also in terms of communications and PR and how they kind of manage their image. So it's quite interesting to see it play out.
And even at like a more fundamental level, the SEC tends to act very prescriptively. They like saying, now you can't do something unless you check boxes 1, 2, and 3. The CFTC is more principles based in their regulation than the SEC is. The SEC is more prescriptive. So the CFTC is not a lax regulator by any stretch of the imagination. Most of the enforcement actions that have been issued in crypto space have come from the CFTC, right? But the CFTC approaches it from a principles-based approach instead of a more technical approach that the SEC prefers.
Yeah, see, I cut my teeth as an executive at CME Group, which is regulated by the CFTC, and came to respect that organization from a knowledge perspective and from a governance perspective, because it was a little bit more trust-based than I think what I'm at least perceiving is happening on the other side of the security side of the marketplace. But I'm sure we will learn a lot in the future. Let me ask you this. So from a RFIA bill perspective, what are the next steps and what are the expected obstacles or challenges that have to be overcome in order for that to become a law?
So right now the bill is in the Senate Finance Committee, Chair Wyden and Ranking Member Crapo. The reason it's in the Senate Finance Committee is because there are tax provisions in the bill, significant tax provisions. Anytime there's a bill, the tax provision just automatically goes to finance. But the jurisdiction over the bill is actually spread over many other committees. It's the Banking Committee, the Agriculture Committee, Judiciary, and Homeland Security and Government Affairs, probably. So all those committees would theoretically have to weigh in, maybe not hold formal hearings, but they would have to weigh in and approve the language in their particular areas of the bill. So passing the entire bill would be similar to passing Dodd-Frank or something like that. So it's not within the same committee's jurisdiction. So that's going to be a very tough, heavy lift. As Rika said, chopping it up into individual pieces is probably the most productive approach. The pieces that will go to ag can go to ag, the pieces that go to banking. I will say that the Senate Finance Committee is working very hard on the tax stuff right now. Many of our tax provisions they've done a request for information, and they're probably going to have a hearing in a couple of weeks on crypto tax. And the Banking Committee is working hard on the stablecoin stuff, and we'll see if the Ag Committee puts out the Stab and Ombudsman bill again. So we're all working very hard on kind of disparate areas, but it's highly unlikely the responsible financial innovation law will be enacted in the introduced form ever. Like it's mainly just here is what we think is a holistic approach to crypto regulation. This is how it fits together. You can all read it all one right after the other, and then break it up.
So when you think about RFIA, which parts do you think are the most, in your perspective, critical to help the industry move forward?
Sure. The age-old question everyone's worried about is what's security, what's a commodity, and that's obviously critical to answer. The second most critical is the stablecoin provisions. The tax provisions are surprisingly important too, because there's so many unanswered tax questions that we need to address. And the U.S. prefers to do regulation through tax policy frequently. So the tax policy stuff is pretty important too. So those are probably the three most important areas.
Well, we're hoping regulation of spot exchanges falls into that category.
Oh yeah, that falls under the definition of security or commodity. Sorry, we absolutely have to make sure spot exchanges have a regulator in the U.S. Hopefully that's the CFTC. There could be an SEC option too, but we have to have some basic consumer protection, custody, and market standards for spot exchanges.
And if everything goes swimmingly, and let's say certain pieces, certain important pieces of that bill progress, what kind of timing do you think would be reasonable to expect?
Hold on one second.
Yeah.
I think, can y'all share what you're saying?
Yeah, absolutely. So, because the timing is critical, and as Rika mentioned earlier, we've had a lot of meetings thus far today, and there's differing perspectives here, but it sounds like it's quite possible that either in terms of legislation or progress in the courts, it could be a while. It could be a couple of years perhaps before any real clarity happens for the industry. And so from my perspective as an operator here in the U.S., that's something we're really going to have to consider in terms of how we manage our business going forward. I think I was overly optimistic thinking that we actually could get to a level of clarity sooner than that. But interesting.
And another thing to think about here is that even if bill passes into full law and is adopted, you can still expect some years of litigation in how different parties interpret the specific provisions of the bill as the new regulation is taking shape, right?
Yeah,
So,
well, as we learned today, or we heard today, there's getting the bill passed. Then it has to be operationalized, which could be a year of rulemaking or longer. And then, to your point, there could be it could be contested in courts. So, how long do you think we should prepare ourselves to live in this kind of ambiguous state?
Well, it depends. If you're a stablecoin issuer, I would say clarity might be coming sooner rather than later.
Yeah.
The spot exchanges probably, I think the judicial process is probably gonna have to work itself out with respect to Coinbase and Ripple before there will be market clarity. So probably 2025, 26.
Great.
Yeah.
No, it's just reality that we all have to kind of start thinking through. This has been tremendously helpful, Chris and Rika. I really appreciate it. We're going to open it up for questions from the audience here, and then I'd like to invite us all to make some closing comments here in a moment. But Matt, do we have any questions coming our way?
We do have a question. I'll just read it because I'm looking at it, and it's: given the uncertainty surrounding crypto regulation, how is Bitstamp planning to maintain transparency and communication with its user base regarding any regulatory changes affecting the platform?
Yeah, great question. I can start. Rika, you might want to chime in. So, firstly, as I mentioned, Bitstamp is really forward thinking, I think, from a governance perspective and from a regulatory compliance perspective. And we've invested heavily in this area. About a third of our entire global staff is focused on the topic of regulatory compliance. And so it's a major investment for us. And we've got a few things that, directly map to transparency. So, one of them is, I'm pretty confident we're the only crypto company on the planet that has had a global financial audit by a Big Four accounting firm for 7 years. So think about that, Chris. In 2016, our founders and leadership team made the decision to not only start auditing themselves or getting audited, but by a Big Four accounting firm. And that's, again, because they recognized then that this is really a game of trust and confidence that we could build with our customers. And so, from a transparency perspective, there's lots of proof of reserves, things and stuff like that. But our estimation, those are all snapshots about that only show one side of the ledger. If you get a clean audit opinion from a Big Four accounting firm on a global basis across your entire operation, that should create a lot of trust and understand the rigor associated with it. Now, the other thing that we endeavor to do is communicate with our customers, and as these legislative and regulatory things happen, it does affect our operation, and we always try to tell our customers about that. Sometimes it affects our terms of use. We always communicate with our customers about that. But we're certainly open to suggestions or input if there's ways we can do that better or differently. I don't know if you want to add anything to that.
Yeah, certainly on the communication piece, I think we try to communicate with our customers as soon as we had the opportunity to assess any regulatory changes and whether it has effect on any products or services that are available in any particular jurisdiction, not just US, we proactively reach out to our customers and give them ample time to make changes ahead of any planned changes to our products and services.
Any other questions come in?
Let's see. Okay. Could you discuss the importance of industry standards and best practices in the crypto space?
Cool. And, Bobby, as you well know, self-regulatory organizations, the National Futures Association in the commodity space, I do think there is a place for self-regulation in the future of the crypto industry. I don't know if that'll be NFA or FINRA or something new, but I do think industry standards and best practices, make everyone's jobs better when the industry regulates itself. You guys are the experts in how your business works and how crypto works. The regulators don't necessarily have that expertise. There has to be some transparency and interaction with the regulators, obviously, but I do think self-regulation and industry standards and best practices, until legislation's enacted, it can get us part of the way there, and then after legislation's enacted, it's important that the industry regulate itself through an SRO that's overseen by the regulators.
Yeah, I love that model, and I think it makes a ton of sense. And I've seen it, to your point, I've seen it work very effectively firsthand in the derivative space. So I'm hopeful. I think we can do more work there as an industry, even in the near term, even ahead of a regulatory mandate, to focus on best practices. And much of what's contemplated in your bill and the bills that we've been looking at, we already do at Bitstamp. But yeah, we're not necessarily talking about that as much as we could be, probably, with from an industry standpoint, in the case that it's helpful. So think that there's more we can do there.
Yeah, and I think if you look at the proposed bills in legislature, industry participants could almost use it as a blueprint for what type of practices and processes should be in place. Absolutely.
Yeah. Any other questions, or should we go to closing comments?
Let's see. Do we have any other questions? Where would you ideally see the industry and the market in a year?
That's a tough question. A year ago, I think we would have probably said something very different than what all of us know to be the truth today, right?
Well, it's quite amazing what has happened in the last year.
Yeah.
So it's even within the last year. So FTX was November, right? Last November. So it's been just like everything else in crypto, just an incredible rate of change and evolution in some challenging ways and some very, very productive ways, I think. And so, as we were talking about a moment ago, I would love for there to be a new level of clarity in a year, but it doesn't sound like in the US that's a given by any stretch. So I think for market participants, we're going to have to, go further in terms of some of the things that were asked, transparency, best practices, basis for operating in a safe way for customers, even ahead of any kind of regulatory clarity or mandate to do so. And I think, with FTX and other things, I think by and large, crypto players want to do the right thing. They take the, client safety and customer well-being and, very, very seriously. But there are a lot of different ways to go at it. And so that's where we can come together as an industry a little bit better, I think.
And I also think that, a lot can change in a year. I want to ask you guys a question.
Mm-hmm.
So, Bitstamp's been around for a minute, 11 years. Was it a red flag for you that FTX was launched in, I think, 2019 and then grew to be the second or third largest player in the industry in a matter of 2 years? Is that a red flag?
It was for me, and I took note of them. I think originally in 2019, when I first became aware of them, and I was trying to figure out how their volumes grew so quickly.
Yeah.
And somebody who's been in the exchange space for a while, and that's not typical.
Yeah.
So I looked into it, and I remember thinking, oh, well, they're owned by Alameda. Well, no wonder, right? So I immediately, in my mind, wrote them off. I thought, well, they'll never get traction because market, traders will not abide by a situation where there's that kind of conflict of interest. And there's so many ways an exchange can create advantage for themselves or for a player if they're trading their own markets. So, that's a big no-no in the exchange space. However, I was wrong.
Yeah.
They got tremendous traction.
Yeah.
And, the other red flag for me, and this is, this might be a cynical view, but whenever I see a technology company, naming stadiums and
Sure.
doing Super Bowl ads, to me, that's like, okay, these guys are going to go down because they should be focused on their product. And if they're not focused on their product, they're trying to distract you from something probably. Now, I didn't foresee a fraud. I didn't foresee this spectacular implosion. But I did think eventually, sophisticated market participants would say, hey, wait a second, this can't be right.
Yeah.
And so, obviously it was much worse than I ever had imagined. But to answer your question, yes, those are red flags to me as an operator.
Yeah, I think, and I think about it quite a bit. I've been through a couple cycles of the market,
sure.
and I think that market conditions play a huge role in our ability to discern high quality projects versus more speculative and questionable projects. And when the market is down, it's absolutely devastating for the industry and it's a hard period. But at the same time, this is the time when you see people focusing on actually building the product.
Yep.
Finding a good product market fit,
Yep.
listening to customers and consumers, understanding what the product should look like, how it will be used, adopting it right to the user base versus trying to play on speculation and the market going up. So it's definitely, whenever the market is going up, it's much harder to discern what's real and what's not.
Yeah. Especially in an unregulated space where,
Exactly.
That's right. Yeah.
Well, let's move to closing comments here. What I'd like to frame for you all is reasons to believe, right? So what have you experienced recently that is encouraging or creates optimism on your part for the industry and for the legislative, foundation of it?
Yeah. So I'll go first. I'm probably the most cynical of the group, just automatically. But I will say that, when FTX happened, I don't think I fully understood what the impact of the collapse would be, probably until like February or March. It took some time to figure that out. I'll say from the period from February to March till about August was very, very bad for the industry in general. Like just people's views of the industry in general, like, prospects for regulatory clarity and legislation were bad. But I will say over the last couple of months, people have realized more, I think, that FTX was not about a failure of crypto and was more about like good old-fashioned fraud, as my boss says. Like the things they were doing were illegal under current law. You don't need new crypto laws to do that. So I think people have realized that, and the ice has started to thaw around the regulatory and the legislative conversation a bit. There's more openness about constructive ideas and the willingness to engage. There's more political will on the Hill to address these topics. We've seen great work in the House from Chairman McHenry on his legislation. Senator Lummis and Senator Gillibrand are going to keep moving the ball forward in the Senate. So I think there has been some thawing over the last couple of months. And, I think as we go into this year, Sam Bankman-Fried's trial starts next week, I believe. And, as we go into the year and try to get some legislation done this year, I'm more optimistic than I have been since the FTX collapse about the prospect of something.
That's great.
Well, I'll continue wearing my lawyer hat, if you don't mind. So the things that I find very optimistic and encouraging is I can see finally in the legislature, like the one proposed, by Senators Lummis and Gillibrand, and in the court decision that we're finally moving away from this narrative is an asset, security, or a commodity, and recognizing that the asset is an asset unless it's equity, debt, or traditional security, and it could be part of a securities transaction that does not necessarily make the asset itself in security. And I think we've wasted so much time in this space debating the topic of whether the asset is a security or not, where this is a different angle of the same conversation, but I think we can make a lot of progress from this perspective.
And I also think that, Rika, as you were mentioning, like, I think the courts have provided some momentum. The courts have checked some of the abuses of the SEC in particular, and I think that will only continue. There's a very interesting case in Wyoming right now that's against the Federal Reserve with respect to stablecoin issuance.
Right.
So I do think the judicial process is going to be very, very interesting to follow in the months ahead.
Yeah. The only thing I would add is just it wasn't long ago, 2 or 3 years ago, that the thought of this much discussion and activity on the crypto topic on the Hill, on Capitol Hill, was kind of unthinkable. And here we have 3 bills out there, lots of focus and discussion. And I know it's a long road, but I think that's really, really encouraging. Yeah. So with that, we need to wrap this up. But thank you all very much for joining us. Thank you, Chris and Rika, for your thoughts and insights. If anyone wants any more information regarding Bitstamp or some of our views here, we have a very active set of content at bitstamp.net. Thank you very much.
Thank you.